last week, USCIS has codified their rules for laid-off workers on non-immigrant visas. When non-immigrant visa workers are laid off, whether you're on an H, an E, an L, an O, a P, they may not be aware of their options, and many, in some instances, wrongly assume that they have no option but to leave the country within 60 days. So when a non-immigrant worker's employment is terminated, either voluntarily or involuntarily, you get fired, you quit, whatever it may be, they can typically take one of the following actions to remain in a period of authorized stay in the United States. They can file an application for a change of non-immigrant status. They can file an application for adjustment of status, or they can be the beneficiary of a non-frivolous petition to change employers. If one of these actions previous to 2016, you had no time, you didn't even have an hour to do it once you got laid off, you became illegal, undocumented. In 2016, they changed the law to say there's a 60-day grace period, and now USCIS has codified that law and made it completely clear to everybody that anyone who gets laid off, anybody who gets fired on a non-immigrant visa has 60 days to figure it out. So as long as you file an application for a change of non-immigrant status, file an application for adjustment of status, or the beneficiary of a non-frivolous petition to change employers within the 60-day grace period, you're still in legal status. The non-immigrant's period authorized stay in the United States, however, cannot exceed 60 days. So even if they lose their previous non-immigrant status, if the worker takes no action within this grace period, they and their dependents may have to depart the United States within 60 days or remain in the United States undocumented. Non-immigrant status is typically based on approved Form I-129, petition for a non-immigrant worker, or after admission, a subsequently approved Form I-539, which is the application to change non-immigrant status. Typically, a period of authorized stay includes the period when a timely filed non-frivolous petition or application requesting an extension of stay or change of status is pending with USCIS. Now, regulations have been codified, and they now permit a discretionary grace period, which allows workers in E's, H's, L's, O's, TN status to be considered as having maintained status in that same classification after they have been fired, after they have quit, for up to 60 consecutive calendar days, or until the end of the authorized non-immigrant validity period. The 60-day grace period is important. Before a regulatory change in 2016, there was no grace period, as I said, for a terminated non-immigrant worker. If you lost your job, you had to leave immediately. The maximum 60-day grace period provides time for non-immigrant workers to maintain their non-immigrant status. Alternatively, the 60-day grace period provides time for the worker to request a change of status, which allows the worker to continue their job search from within the United States. It also provides time for certain spouses of non-immigrant workers to continue working if they have an authorized employment document, a work permit. Within the grace period, eligible H-1B non-immigrant workers may also begin employment again as soon as they find a new employer, and that new employer files an H-1B petition rather than waiting for that new petition to be even approved. A worker filing for employment in another classification, unfortunately, would have to begin employment only once the new petition is approved, but given the availability of premium processing, the wait for petition approval can be less than 15 days. The maximum 60-day grace period starts the day after termination of employment. USCIS will determine whether the grace period applies to your case during the adjudication of a subsequent extension of stay. And the grace period may apply to voluntary and involuntary cessation of employment. Basically, you're fired or quit, doesn't matter. But working during that grace period is prohibited. You would be working undocumented. But you have that 60-day grace period where you are still in authorized stay, can't legally work until you find a new sponsor, but then you can extend your stay. So typically, somebody gets fired, you're now given 60 days to find a new employer to file a new application. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.